Hello, good evening and welcome to another program on law and order. Tonight, we're going to discuss on an area which derives from the Latin term parate. We heard about parate execution. This term comes across when we are talking of recovery of loans by banks. But is it the same as debt recovery or is it different? Tonight, we are going to go to the heart of the matter with an expert on the subject of parate execution and the laws relating to that. My expert guest today is none other than Senaka Saram. He is an attorney and has specialized in the area of parate execution as well as in other areas of law. Senaka, thank you very much for coming again to Rupavahini. And how are you today?
Thank you, Senaka, for inviting me.
You're doing good.
Good evening.
Yes, this is an area, like I said, we have heard about this. Lawyers have heard about this, people who got in litigation have heard about this, but a very rarely discussed area of law. Can you first explain to me what is the word parate means?
Yeah, what parate law actually means, Chanaka, is where the banks are entitled to auction a property that is mortgaged to them for a facility taker. So this is more or less performed today by banks through statutes. So you have the Recovery of Loans by Banks Special Provisions Act, where private banks will exercise parate, and then you have the People's Bank Act, the Bank of Ceylon Ordinance. So the banks have this right through a statute. So if not for these laws, one cannot execute your land which is mortgaged by way of sale by themselves. Now, this is a process where they by themselves can pass a board resolution and sell your property if your facility is in default. So earlier they couldn't do that. They had to go to court and get a court order to sell your property which is mortgaged. So these acts provided for that.
Right. Now, can any property which has been mortgaged be sold, or is there like a way of classifying on this area?
Yes, every property can't be sold. There are certain exemptions to this. That means, for example, in 2011, they brought in an amendment to the Recovery of Loans by Banks Special Provisions Act, where any facility which is below 5 million, then the bank was barred by trying to execute this parate because they thought it was harsh. So if your facility is 5 million rupees and below, then the bank cannot execute parate. And also there is a definition of what 5 million is. So it's basically, it leaves out interest and penal interest and things like that. So it's basically like the capital amount. If you have been paying a loan and it has fallen below 5 million rupees, then you're safe, I should say, and they cannot execute parate. Because you see, it's a very draconian law. It's a one-sided law. It's in favor of the banks and it flows and all. But there is also another element of property which can't be subject to parate execution, which is third party properties. That means where the borrower and the person who mortgages the property are two different people, then the prohibition for executing parate on those properties are also there. This, of course, was brought about by case law. I think, Chanaka, you would have also heard of the famous Ramachandra case versus HNB, which was delivered by a former Chief Justice. It was a full bench decision of the Supreme Court. That case brought about the third-party mortgages, where you cannot sell third-party mortgage properties.
Now, you mentioned, before we go further, you mentioned about this law being a very draconian law. Is it a very old law as well?
It's not an old law. It has been created by statutes.
Yeah. Have there been changes towards any due to the nature of the necessity of people or the banks? Has it been changed in the recent past?
Yeah, there are changes now. The changes are coming about basically to restrict the bank's ability to execute parate. As I told you, the 5 million rule.
Yes.
So those are the changes that have been brought about, but otherwise it is a situation where the bank can pass a resolution and sell your property if you are in default of the facility.
Right. Now, what about companies where, for example, the directors' properties, they must have been mortgaged, right? If they are mortgaged, directors' properties. Now, does the parate law applies here, or is it different?
Yes, now that is a situation, that's a good question you asked. That is because sometimes companies are floated by individuals and the company itself may not have assets. So what the directors used to do is they used to give their personal assets to the bank and obtain a facility for the company. So as you know, the company and the directors are two different individuals legally.
Yes.
So then the issue came up whether you can execute Parate on the director's property, because that I said is like a third party mortgage,
Right.
where the person who has mortgaged the property is different to the person who has taken the facility. The facility is taken by the company, while the person who mortgages the property is the director.
Yeah.
So basically the case law which I told you has barred sale of third party mortgages, but there is an exception where the Supreme Court in one or two cases, in isolated cases, have said where the director has participated in the company, as he has benefited from the loan and he is involved in the loan and in the whole process, then the situation where the third party rule, which I stated a few minutes ago, does not apply. So if you are a director who has benefited and who have been actively involved in the taking of the loan and who have been involved in the company's affairs, the Supreme Court has, in one isolated incident, has said, no, your property is liable to the Parate law.
Right. Now, going back to the same situation, if the director was not benefited, some directors who are just there as to help the company, their mortgage, is the situation different in that?
Yes. Now the law and even the Supreme Court decisions are shifting towards those directors, in favor of those directors, where they have said, no, the law is very clear, the person who has taken the loan is different, the person who has given the property is different, so we will not execute Parate against third party properties. So it is only those isolated situations, I said, that you can cover yourselves from the situation where the bank has executed Parate on a director's property.
Okay. What about companies that are going into liquidation?
Yes.
Now, in that situation, are their companies' properties subject to the Parate execution if they had mortgaged?
Yeah. That area is actually very complex. As you know, when a company is subject to winding up, there is a schedule in the Companies Act which sets out how your liabilities are to be disposed of and who is to be settled first. So it is basically the statutory debts that have to be paid off first.
Yes.
So then what banks used to do is, because they knew that they are down the ladder and they get nothing once the assets are sold and all the other liabilities are settled, the banks took up the position that no, we are executing Parate against this property, we have the right under the law, so we will auction this property. So there was a dilemma whether the Parate law supersedes the winding up provisions or whether the winding up provisions will supersede the Parate law. So it was settled in a case in the Court of Appeal, and where it was held that once the winding up proceedings start, then a bank cannot execute Parate on the properties which are owned by the company. So that will fall into the general pool and it will be settled according to the winding up act, which is the Companies Act.
Will they get priority?
They will not get priority, because first it will be according to the Companies Act, according to that schedule I said, the government's liabilities and so on. But if it is a primary mortgage, they will get priority based on that schedule.
Right. Is that, in your opinion, is that correct? Is that fair?
I think it's fair, because in a winding up application, it's basically every creditor is subject to a winding up process. They advertise it on the paper, there is an inquiry, the debtors are set out in the winding up. So for one isolated individual just to take a piece of the pie, I think it might not be in the interest of all, because the winding up application looks at everybody together. So I think in that way it's fair.
Can you walk us through the procedure that banks adopt for Parate execution type of a sale?
Yes.
How does it happen?
First of all is, you will know, if you are a person who has taken a facility from the bank, you will know that you are in default. That is where the triggering point starts. And that is the point where a lot of people forget. I mean, if you foresee that you are unable to pay this loan, and if it's above 5 million rupees, it is good that you go and see somebody with some legal knowledge to see how you can get out of these draconian laws. There are instances where you can get good legal advice, and maybe prevent your valuable properties being auctioned off. But to come back to your question, it will start with a letter of demand. Moment the bank realizes you are unable to pay, then you fall from the good books of the bank. Sometimes you are a premier customer, and then from there onwards, it's a slippery slope downwards.
Yes.
So they will send you a letter of demand. Then if you don't respond to that, which generally happens, people don't respond to that. So as you know, there are case law to say if you don't respond to a letter of demand, it's as if you have admitted to that fact. Then they will send you a notice. They will send you a notice saying the board has resolved that they are going to auction your property. So they will pass a board resolution after the letter of demand, and they will issue that notice to you with the board resolution. Still if you don't respond to them, then they will appoint auctioneer, appoint a date. Now all these things, Chanaka, it will start from the letter of demand, then they will publish a board resolution. That will be published in the Gazette, in the newspaper. So you cannot say that you didn't know. It has been published in the newspapers and the Gazette. It has been communicated to you through a letter. Then still if you are silent, they will appoint a date for the auction. That will be also published in the Gazette, communicated through you, and they will advertise it. So all these steps, as I told you, Chanaka, is done by the bank unilaterally, without any, they have unfettered powers, I can say. So they can do that within their bank. They just go ahead with all these procedures. So that is why I am telling you, if you are faced with a situation like this, as soon as possible, you must go and meet somebody who can advise you how you can get out of this situation.
Right. Now, can you also tell us the procedure how it would happen in court?
In court, yeah. Now there are two ways.
Beyond what you said.
Yeah. There are two ways to stop auction. One is you pay up the money. I mean, if you can do that, then there is no reason for the bank to go ahead with auction also. Generally, that won't happen. That is why you are in default. You have no money. So then the issue is you have to go to court and stop this. So as I told you earlier, if you had not taken your proper precautions when the initial part of the letter of demand is sent, then you are in serious trouble by the time you come to the end of the process. Because the bank, you have to understand they are a bank with sometimes a very good legal department. There are experts in that department. They have been working there for years. They know how to do this very well. So they will quickly go through this process. So then you have issues like if you go to the court last minute, the courts also will ask you, why did you stay till the last minute to come here? So if you have to go to a court of law and you have to get an order stopping that auction. If that doesn't take place, the auction will go ahead. And you are in a serious situation then because you have lost your property.
Okay. What is the chances of stopping an auction like that, given the fact that if you have neglected the letter of demand, and as you said, there are case laws which says it amounts to admission, and how does what are the chances of still, if you have not followed the procedure, ignored, not paid, and ignored the letter of demand also, and still if you come to court, how does the judicial thinking these days?
Yes, if you fall under the exemptions I told you, below 5 million, if it's a third party mortgage, if there is a very good legal chance, the courts are not hesitant to grant enjoining order. Now we have seen situations where clients have come to us and the courts have given the enjoining orders. That is because we have managed to either create a situation where we have a good case, or we have fallen into those categories that I said where the banks cannot execute Parate execution. But if not, most of the time some of the courts are inclined to be with the bank because you are in default for a long period of time. From we'll say the stage of letter of demand to the date of auction, it may be 1 year sometimes or 8 months. So they are also worried because they feel that commerce should proceed. And if there is a default, the bank should recover and the law is there for that. So it all depends on how you have handled the situation.
Right. What if in the same property, several loans have been taken? Now, if there are situations where several loans are taken and one loan is in default, which is one property. Now, how does the Parate law applicable here?
Yes, for that question, Janaka, there is direct reference in the Act. Even if one loan is in default, they still can execute Parate for that property. So you can see how draconian this law is.
Yeah, that's true.
So even if you have 10 facilities with the bank,
Yeah.
and 9 are okay, and 1 is still in default, still for that one facility that is in default, they can go ahead with Parate. They'll publish the board resolution and go ahead with Parate.
Okay, we'll say that happens. We'll say somebody has a property which is worth 100 million and he has taken 3 loans, 25, 25 and 50, and 25 is in default. So they go ahead. This guy also doesn't go to court and to stop it, and the properties are sold.
Yeah.
And he says the bank gets the exact total value. What happens to the balance value? Do they return it?
So once they auction the property, now if you take the Bank of Ceylon Act or not, they can net it off with the other facilities that are, if they are in default. If they are in default. If not, what they will do is they will auction the property, they will net off the dues that are required, including auctioning charges, all that they are entitled to net off, and they should return that money back to you. But in a practical sense, even if the other facilities are not in default, they might try to retain that. They might try to retain that, saying that the other facilities are in default.
Okay, what's the recourse in that point?
Then you will have to have a separate case to say, give me back my, you'll have to go to court.
To get that, we'll say, in my example, the balance 75.
The balance 75. But generally what they do is they return. They are not going to keep money which is not due to them.
Yes.
So this situation it gets complicated when there are so many facilities. Some are not in default, some are in default. So generally the banks try to negotiate and get even the one that is in default, get it up to level of a stage where they don't need to go for Parate. Because they also are aware by selling one property, what about the other facilities that are there with you? They in their interest, the facility is money for them. So they would like to keep the customer going. So that situation is there in isolated situations.
Right. What happens to the property like after the auction?
Yeah, there are 2 things that can happen. Sometimes a person can come and buy it on the auction day. Sometimes this doesn't happen. So in that situation, the bank takes over the property. And thereafter what the bank does is it executes a thing called a certificate of sale. So the certificate of sale is also a legal document in terms of the act. And once that is executed, you cannot challenge the process of the auction that was done by the banks. So that is also there in the law. So as I told you, it's a very draconian law. And even in the Ramachandra case, I'm sure you have read it, it explains how draconian it is. And it goes on to paragraphs of how draconian it is. And thereafter, you cannot challenge the ownership of that property once that certificate of sale is done. And that is also done by the bank. Their legal officers will do that. So that
how does the buyer or whoever, the purchaser, gets the possession? With this document or?
No. What happens is generally once the auction takes place, in reality, that particular, if it's a bare land, there is no issue. But we'll say it's a building or a house or something, sometimes the people are still there. So though the ownership has shifted by the certificate of sale, the possession is not there, which is sometimes no use to the buyer. Then in these acts, which I told you earlier, the act also specifies how you can get rid of a person. So you don't need to go and follow the normal procedures where you are filing a case to get rid of like a tenant or some trespasser. The act has a very speedy process, and you can file action where in the district court of Colombo or where the land is, and by way of summary procedure, you can be thrown out of your property. So not only you, any third party holding under you also can be thrown out, and these cases come up very often where you have no defense, because as I told you earlier, they have executed the certificate of sale and they lodged the certificate of sale in the relevant district court, and you have no defense because the act itself says you cannot challenge that process that was there, and ownership is vested by the certificate of sale. So you are in a very awkward situation if you don't stop that auction, as I told you earlier, by taking relevant steps.
Right. Now what happens to the proceeds of the sale? That just goes to the bank and...
what they do is they credit it to their account, and if there is any surplus, they will give the
Yeah,
surplus.
like you said earlier.
Like I told you, they will
Yeah.
definitely give the surplus back to you.
Okay. Now the transfer, the ownership deed, how does that process? Who registers that on behalf of the purchaser?
Yeah, the certificate of sale will vest the ownership with whoever who purchases the land.
Okay. You don't need a separate deed after that?
No, that is the certificate of sale. But what happens is when the bank purchases the property, then the certificate of sale is in the name of the bank.
Yeah.
So then if somebody comes to buy this later on, then you will need to have another transfer deed from purchasing from that certificate of sale.
Okay. We went through the process of how it can be stopped earlier. But does all courts have jurisdiction to issue that enjoining order?
No, Chanaka, this is a very good question actually for some of our practitioners.
Yes.
Because there are clients that we appear for banks and we fight these cases for the banks.
Yeah.
And we find that our own colleagues sometimes file these cases in wrong courts.
Yes.
So as you know, the preliminary case is where you're challenging the auction process. So the auction process, all that is done in the bank at a head office in Colombo. So generally you have to file these cases in Colombo. And since, as I told you, below 5 million rupees you cannot execute Parate, above 5 million the jurisdiction is vested with the Commercial High Court. So you have to more or less file it in the Commercial High Court and get your orders from there. When it comes to the People's Bank and Bank of Ceylon, they have their own acts, as I told you. There are ouster clauses there, which says that you cannot challenge those procedures. So for those sort of banks, you have to go to the Court of Appeal and obtain a writ. So this is the area where people forget, even our own colleagues sometimes. Sometimes they file cases outstation where the land is situation. It's not a land case, though it concerns your land. It's a situation where you're fighting a case because of the board resolution. So even though there are case law to say that those cases filed outstation are not valid. So then the person who has got an order in the outstation court ultimately wonders what has happened, because they initially get an enjoining order and then later on court says I have no jurisdiction to hear this.
Right. You said this is a very draconian law, and two questions together. Why isn't there been any attempts to change the draconian part of the law? And in any event, what is the advice you would give to people who are about to get caught or caught in this kind of situation at the moment?
Yeah. The background to this act is, Chanaka, is the situation where the institutions are facing the delayed justice system in our country. You know that. So the government had, at that time when this legislation was put out, they had to do something where procedures are in place where the banks can recover their money soon. Otherwise, the banking system was coming to a dead halt. So that is why these acts were put into place. Otherwise, you will have to file normal cases, and these will go on for years for them to recover. These are very quick method. And as you see, these can be only implemented when you are in default. And that also, for all these procedures to take place, it will give you a window of time to do something. So in those, that is the reason why this act was brought in. So I don't think now the legislature will go back and try to safeguard or try to protect the default. But they have done so by limiting it to the 5 million rule. So the small men are spared. And coming to your second question, what should you do? That's a good question. You know when you are in default, you know when you can't pay. You know that you will have no money to pay. Then it's time you go and see somebody and get advice. And that person, if he is competent, can give you some very good advice to save your property. And I think that is the first thing you should do, without waiting till the last minute, because otherwise you are at the mercy of a judge who sometimes may not think your conduct is not that great. And if he doesn't give you that enjoining order, your property, which is worth more than the value of the loan, will be lost.
Mercy of the judge as well as the bank.
And the bank.
Senaka, Saram, thank you very much for those very insightful thoughts on Parate execution, and thank you for joining Law
Thank
and
you,
Order today.
Chanaka.
We'll see you once again another time. Yes. That's Law and Order for today. We'll join you next week at the same time with another program on Law and Order. In the meantime, you can join the conversation by logging into the Facebook page of ours, that's Facebook/Law and Order Channel I, and you can log into our channel page, that's channeli.lk, and go and check the Law and Order page and watch the all programs over and over again if you would like to. I'll see you next week. Have a good night and a good weekend. Enjoy the rest of the programming on Channel Live.